Good afternoon, class.
Good afternoon.
Good afternoon.
Good afternoon.
Oh, I hear a little bit of enthusiasm. I like that. So I got an email. I think one person will find a case, and if someone is missing or no, I mean, tonight they can join in and do that one. I think that'll be the Monaco.
Dominique.
Dominique.
Dominica.
Okay, all right, Dominica. Let's see if someone is in here. If not, you'll get one for next class.
Okay.
All right. So who wants to start first? I want in lieu of, you can read unit 8 yourself. I want us for unit 8 to read our last case tonight will be Scotiabank versus Cube. And so maybe Dominica could do that one because I don't see Demetria on. Demetria, are you on? Because I don't see her here. Okay, Dominica, you can look at that one in the meantime.
Which one is that?
Scotiabank versus Cube.
Okay.
Okay. Janine, you want to start with Bank of the Bahamas and the Delavos?
Sure.
Okay.
Okay. My case is in the Supreme Court, Common Law and Equity Division between BOB, the plaintiff, Bank of the Bahamas, and Christensen Delavo, the first defendant, and Marilyn Delavo, second defendant, before Justin Ian Winder. The Delavos took out a mortgage with BOB over Lot 15, Block 16, Section 2, Seabreeze Estate Subdivision on March 16, 2005. On February 27, 2017, BOB filed an originating summons against the plaintiffs seeking payments of funds owed. Payment of the sum of $258,485.37, being $227,540.06 as the principal, and $30,245.31 as interest, outstanding up to August 16, 2016. Calculated at the rate of 7.25% and continuing thereon at the said rate of 7.25 per annum or $44.96 per diem down to the date or dates of payment, and $700 as to late fees. Delivery of the defendants to BOB of possession of the property as charged by the mortgage to secure the money previously mentioned. On March 14, 2018, Hilton J. granted vacant possession to BOB and gave judgment as paid with interest and costs. The Delavos appealed on November 29, 2018, and the Court of Appeal allowed the appeal, remitting the matter to the Supreme Court. In February 2020, the Delavos applied for dismissal of this action, which was supported by the affidavit of Christensen Delavo, filed November 22, 2019. BOB relied on the affidavits of Silbert Clark, who is an assistant manager, Retail Recoveries and Collections Department, and Anton Higgs, manager of Special Activities Department. BOB acknowledges the fact that the judgment of the Court of Appeal caused this matter to be remitted to Supreme Court for rehearing. The court determined that BOB must provide verification of the judgment amount and that until proper accounting was provided, the writ of possession, which was ordered by Hilton J. to enforce the judgment, would be stayed. In the extempore judgment of the court, Evans J.A. stated the bank provided information which intended to verify the amount owing. However, after the information was reviewed, it was quite clear that there was some discrepancy that they have not been able to explain sufficiently. The appeal was allowed and matter remitted back to the Supreme Court for a proper accounting to be done so that the judgment amount can be verified. The execution of writ of possession was ordered to be stayed pending such accounting. If on the completion of the said accounting, the information indicates that the powers of the court under Section 3 of the Money Laundering Act should be invoked, an application should be made thereunder. The Delavores submit that BOB has refused and continues to refuse or are unable to present a proper accounting of the mortgage account. They continue to present the information provided previously, which the Court of Appeal found that there was some discrepancy. The Delavores go on to list a number of alleged discrepancies. They calculated a $30,327.39 difference in the mortgage amount BOB alleged was owed by them. There was a difference in the mortgage account numbers. BOB never provided any statements from inception of the loan in 2005 to 2007. BOB claims that they are that the Delavores are 53,156.5 installment payments in arrears, which was impossible. BOB failed to comply with the Court of Appeals judgment to provide accounting, and the statement provided by BOB commences on October 1st, 2007, with a credit balance of $2.29. There is nothing showing a transaction on the account on October 15, 2007, when the account statement begins with the aforementioned late fee of $35. None of the dates on the account statements are reconcilable on the loan statements provided by BOB. And more specifically, the defendants contend a fraud is being perpetrated on them by BOB.
I didn't understand that.
Okay. BOB conceded that the Court of Appeal saw a discrepancy between the balances on the mortgage account because they used two separate accounting systems to keep track of mortgage accounts, which was the business object statement, BOS, which stated the balance was $290,120.89, and the Flex Cube statement, which stated the balance was $259,793.50. On December 17, 2018, following the Court of Appeal decision, the Delavores wrote to BOB seeking an accounting from inception to that date. BOB stated that the discrepancy was explained in Higgs' affidavit, which explained the amounts owing under both systems, and explained that the difference arises in consequence of the difference in the processing of postings on the both systems. His affidavit also explained the change in account numbers, which was due to change in the processing systems. BOB contended that there was no confusion regarding the Delavores mortgage account. They submitted that they were compliant with Order 77, Rule 4 of RSC, as they provided the Delavores as specified with the amount of arrears. They submitted that the Delavos did not challenge the fact that their mortgage loan was in arrears. No evidence had been provided to contradict what they said was actually paid on the mortgage. They claim that accounting is accurate and they would be willing to concede the lesser amount. The Delavos did not address the proposition by BOB. However, they did say that in addition to the discrepancy, they have been saddled with unknown additional loans added in together with legal costs. The Court of Appeal having ordered the parties to bear their own costs, so that should not be so. While the defendant did not elaborate on what they deemed to be unknown and additional loans, upon examination of the statement exhibited by both parties, the judge found that there were 6 instances where legal fees were added, the last 2 being after the order of the Court of Appeal was handed down. BOB did not address that complaint. So the disposal, the judge said that defendants have not brought or even suggested that there is evidence that they are not in arrears on their mortgage and are not responsible for any such arrears thereon. They simply contend that the plaintiff has not provided a proper accounting of the mortgage loan from its inception. Indeed, the Court of Appeal did not find that the plaintiff had given a proper accounting. The entire purpose of such an accounting, as opined by Evans J.A., was to allow the court below to verify the judgment amount. The judge did not find that the plaintiff had met the Court of Appeal's mandate to provide an accurate accounting to the defendants and the court in order to enable the judgment amount to be verified. The judge said that even if she was able to accept the explanations provided by the plaintiff for the discrepancies in the mortgage loan account and allow them to use the lesser amount reflected by the FCS, there has been no explanation given for legal fees being added to their account, particularly those listed after the Court of Appeal judgment. While the plaintiff had not, in his opinion, provided the necessary accounting mandated by the Court of Appeal, he was not persuaded that the defendants should be granted the dismissal of the plaintiff's originating summons as sought. It is an apparently undisputed fact that the defendants are in arrears on their mortgage loan. The Court of Appeal judgment did not appear to find otherwise. The writ of possession having been stayed by the Court of Appeal, the plaintiff has not satisfied the court that the stay imposed should be lifted. He would grant the plaintiff an additional 90 days to provide a satisfactory accounting to include an explanation for the legal fees that were applied and to have such fees removed and the account adjusted accordingly to reflect the true balance. The stay of the writ of possession to continue pending the accounting by the plaintiff, and there shall be no order as to cost.
Okay. Any comments? What was happening in this case?
BOB, they should have just stick with one amount, like choose an amount and go to court with that and not provide all of those different figures.
Sounds like they had 3 or 4 people doing accounting.
Yeah, but it also appears as if when they move from one system to the next system, no one bothered to check to see if the numbers were in agreement.
Correct.
Right. So remember in last class when I said to you that the mortgagee themselves have an obligation because it is a contractual relationship, just like any other contract that you enter into, and they have a duty to their customers. You cannot go before the court and you know that the figures that you're presenting is not accurate. How can you go before the court and say, I had 2 different systems or 3 different systems, so I have 3 different figures? But,
They
but you,
should just put one.
right, but you want vacant possession. Yes, the court will give you vacant possession, but you have to be able to demonstrate to the court that the figure that you're asking for is accurate.
They making it seem like they had a manual system, like that couldn't have been computerized.
I don't know. Maybe they had an old system and then they had a new system. They said they had 2 separate accounting systems. I don't know what bank has 2 separate accounting systems. How can you have 2 separate accounting systems? Unless you had a new one and an existing one and they were being run parallel. You know what I
Uh-huh.
mean?
And in other, when they spoke later, it seemed as though one was an old system that they no longer used, and then they moved to a new system. So
And
I don't
that's
understand why
right.
they went on the old system. They basically should have just used the figure from the new system.
Because that means that when they move from the old to the new, nobody reconciled it.
Nope.
Someone should have checked the balances, the opening balances on the new versus the closing balance on the old to see
Yeah.
what was the difference. But they do have a duty, a fiduciary duty. So yes, they can exercise their power of sale. But the court is saying prior to doing that, you have to come to the court with the right balance.
Yes. And they
Okay.
didn't even try to account for it. They just say, okay, just give me the lesser amount.
Yeah. Yeah. You'll see in a lot of matters that come from this bank, it's like it's sloppy work. Let's just throw it together, prepare an affidavit, and let's see what we get. Rather than following what the law requires. Okay, let's look at Scotiabank and Ricardo Gibson. Isn't that Dorame?
Yes,
Okay.
yes, ma'am. Okay, so I have Scotiabank being the plaintiff, Ricardo Gibson being the first defendant, and Beverly Gibson being the second defendant before Judge Justice Gregory Hilton.
Mm-hmm.
Plaintiffs filed on March 5th, 2015, applying for court to correct what is says to be a clerical mistake in an order that was dated 17th of May, 2010, granted by Justice Bernard Turner at the time. Defendants are objecting to the application of the plaintiff and has filed an affidavit dated the 2nd of November, 2015. The plaintiff's summons is made pursuant of an order 20 Rule 10, which provides clerical mistakes in judgments or orders or errors arising therein from any accidental slip or omission may at any time be corrected by the registrar. The plaintiff had entered a mortgage agreement with the defendant on February 15, 2005. The defendant subsequently fell into repayment arrears on the 18th of November, 2009, which originated the summons which was filed. So the claim was for all monies due and owing to the plaintiff by the defendants under the said mortgage, delivery by the defendants of possession to Scotiabank being the plaintiffs, limited over property lot number 17 and subdivision known as Westridge Estates. Further and other relief and costs. A memorandum of notice was filed in December 10, 2009 on behalf of the defendants by Monroe and Associates. So on 2010, May 17th, before Judge Turner, Donald Sanders appearing to the plaintiff, but no appearance was made by the defendants or their counsel, even though they had an appropriate notice of the hearing date. So the judge ordered that the defendants do give and deliver up to the plaintiff's vacant possession of the property comprising in a mortgage dated the 15th day of February 2005 between Ricardo and Beverly Gibson and Scotiabank. And that all costs of the action be and is hereby granted to the plaintiff in any event to be taxed is not agreed. The perfected order was served on the defendants on the 19th of July 2010 and on the 27th of January 2011. The property was advertised for sale, being appraised at $953,000. It is to be noted here that in August 2009, the counsel for the plaintiffs had written a final demand letter to the defendants, indicating the intention of the plaintiffs to sell the property for $630,000, and that the total amount outstanding, inclusive of interest and miscellaneous add-on expenses, was at the time of $571,586.09. On the 7th of May 2013, the property was sold for a sum of $500,000, and $413,378 was applied to the defendant's mortgage loan. By letter dated the 31st of January 2014, the plaintiff's attorney wrote to the defendant stating that defendants were still indebted to the plaintiff under the mortgage loan and demanded repayment for the principal sum of $57,230.62 together with the accrued interest of $252,358.86 and miscellaneous add-on charges of $43,434.39. The plaintiff subsequently filed a summons on March 5th, 2015, seeking that the court have correct a clerical mistake in that all monies due and owing to the plaintiff by the defendants under the said mortgage. The law, Order 20, Rule 10, referred ante, is commonly known as the quote-unquote slip rule. The rule speaks for itself and is only issued where it applies on the facts of this case. So Judge Turner says he's under the view that Jay's order, which is the previous judge, prayed, can only properly and fairly be interpreted to mean ordered as prayed in the originating summons. The subsequent order, which was drafted by the counsel initiated by the judge, omitted the first claim in the originating summons, and as such may be considered to be clerical mistake falling within the ambit of the Order 20, Rule 10. The court must also consider, however, whether it should be exercised its discretion to correct the error or mistake. The plaintiff's counsel has submitted the correction of the mistake should be made to give effect to the attention of the court where an order is drafted and perfected, which did not specify the entire order, but only part of it. The defendants have submitted that the court should not order any correction because of the extensive delay in bringing the application without explanation, and that to do so would cause prejudice to the defendants. Disposition. While I find the order made by J. Turner on the 17th of May 2010 contain a clerical mistake or omission, which could be corrected pursuant to the Order 20, Rule 10, I do not accept that I should exercise my discretion to order a correction due to the inordinate or unexplained delay in making the application, which I find will cause prejudice to the defendant if it's corrected, which prejudice is outlined in para 17 to 21 of the defendant's affidavit. The plaintiff's summons was dismissed. So in a nutshell, 5 years later, DOB realized that there was an error in the amount that was actually owed by the defendant. And 5 years later, they want to go back to court to have the judge correct the error so that the defendants could actually pay that outstanding amount. And the defendants, like, it wasn't fair to them. They'd already gone on with their lives. They already lost their house. They gave up possession, and the court ordered them to pay a certain amount, and they were paying on the amount. It wouldn't be fair for them to go back to court to have to pay the additional cost 5 years later. Anything else I missed, Ms. Aksha?
Mr. Archer ain't in the room.
Yeah, her internet must have gone off.
Our exam's still on for this week. When is it? Wednesday, right?
I think so. Anybody know how is it how it's going to be delivered
No, we don't.
That's my question.
and the time? Yes, I'm kind of curious.
I'm thinking it's gonna be similar to the Google Docs, where if it's anything like what they did for the last class, they supply the question. She's back.
Sorry about that.
Ms. Archer, where were you when I was giving my whole conclusion?
I need your conclusion again. I don't know, the internet had low mode and then it just dropped.
Okay, so the judge threw out the case for the plaintiffs, which was Scotiabank, because the case was for a correction, and the correction is being noted 5 years later. So the defendants was like, it ain't fair to us. We done give you all the house. We done paying on the difference what we owe. 5 years later, now y'all coming back with a different figure. This ain't fair to us. So the judge said, yes, in the law, they can go ahead and make corrections with the registrar. However, because they took so long, he don't think that it was fair on the defendant's behalf, and he threw out the case.
Okay, now, I remember you raised, not you, but I mean the class raised this point. Let me see if I could find it for you. Section. Section 7 of the Homeowners Protection Act. So everybody understood what just happened in that case, where the bank came back after 7 years, realizing that there was a mistake. So under this would have been prior to the Homeowners Protection Act. And you see how the court said it would not have been in good order for them to go behind now after that length of time to request a change because of their mistake. So under the Homeowners Protection Act now, it says under section 7, section 11, subsection 7, It says where a mortgagee sells the mortgage property for a sum higher than the mortgage debt, the mortgagee shall pay such remaining sums to the mortgagor or to their heirs or assigned, save for any surplus amounts referred to in subsection 7. The exercise by the mortgagee of a power of sale shall discharge the mortgagor from any and all liabilities for any sums due under the mortgage if, at the date of the sale, the sum equal to at least 1/2 of the principal and accrued interest has been paid to the mortgagee, or the mortgagor has been in occupation of the dwelling house for a period not less than 50% of the original mortgage term. The mortgagee shall, upon conveyance of the mortgage property, execute a deed of release in favor of the mortgagor. And the provisions of this section shall apply to all mortgages, notwithstanding any provision in any other law or custom, or any clause contained in any mortgage document executed before or after the coming into operation of this act. A mortgagee exercising the power of sale in accordance with the provisions contained herein shall not be liable to a mortgagor for any claim or claims for loss or damage suffered by the mortgagor by reason of such sale. So the Homeowners Protection Act has actually put in law protection for the mortgagor.
Ms. Archer, which page it was on just now?
That would have been page 8, section 11, subsection 7.
Not in the manual, eh?
No, this is in the Homeowners Protection Act,
Oh, okay.
the actual act.
Ms. Archer,
Mhm.
in the manual, it states that a mistake will not affect the validity of the banker customer contract unless there is a serious mistake of fact. The mistake may be made as to the subject matter of the contract and the signing of the written documents and the identity of the parties. The mistake is proven to have occurred, the contract is considered void. So in a case like that, wouldn't the contract be considered void thereafter?
You mean in
Saying that the mistake was on the bank's behalf.
ah
I mean, why did it have to go as far as the court, saying that the banks made the mistake and
Because-
the error on their behalf?
yeah, but they had already had an order from the court.
Yeah.
So once you get an order from the court, you have to follow the order of the court. So if the
Okay.
order of said $10, they couldn't come back and ask for $10.01.
Okay.
Right. The court has to correct that. So they made a mistake. But you see, don't forget now, when you deal with the court, time is important. Timing. So you coming back to collect, okay, so in section 11 of the Homeowners Protection Act, subsection 6, it says the mortgagee shall at his option accept the highest price offered for the sale of the mortgage property, even if the price is less than the market value, and shall on receipt of the proceeds of such sale apply the same to the sums due and owing under the mortgage. So it is up to the bank when that order is sent to the judge to be perfected to ensure that it records the correct figure. So you remember in sections and in paragraph 11 in the case, it said the perfected order was served on the defendants on the 19th of July 2010 and on the 27th of January 2011. The property was advertised for the appraised value of $953,000. It should be noted here that in August 2009, counsel for the plaintiffs had written a final demand letter to the defendants indicating the intention of the plaintiffs to sell the property for $630,000. And that the total amount outstanding, inclusive of interest and miscellaneous add-on expenses, was at the time $571,000 plus. And then in 2013, the property was sold for $500,000. So here, what the bank is trying to do is to recoup its difference. And under the Homeowners Protection Act, you cannot do that. As long as you meet the requirements under Section 11. Okay, Zena, you want to do QBC?
Yes, I can.
Okay, go ahead.
Okay. So this case was brought before the Supreme Court in the Common Law and Division and Equity Division before Justice Indira Charles. And it was between the plaintiff Quality Business Center Limited, the defendant Anthony Munnings, and the third party Harmony Homes. So in this case, Quality Business Center Limited instituted an action against Anthony Munnings, seeking damages in the amount of $287,600, including stamp duty and legal fees for fraudulent misrepresentation of 9 lots of land known as Lake Belanis subdivision located in the Western District of New Providence. On the 17th of June, 2016, Quality Business Center was successful in their application for judgment and admission. And Anthony Munnings was ordered to pay $80,000. This was the money he admitted to receiving with regards to 5 out of the 9 lots, along with an additional lot not mentioned in the statement of claim. The remainder of Quality's claim was set down for trial. On the 4th of November 2016, the plaintiff filed an amended statement of claim. On the 14th of September 2017, the trial began. And after the witnesses had testified, the parties were ordered or directed by the court to provide original submissions on or before the 21st of September 2017. On the 25th of October 2017, more than a month after the original submissions were provided, Anthony Munnings, through his attorney or his counsel, Mr. Nicholas Zervos, provided the court and counsel of the plaintiff with amended submissions. The amended submissions raised new issues and these new issues were not initially pleaded. So out of fairness to the plaintiff, the court reconvened on the 18th of January 2018 to give the plaintiff more time to address the new issues that were raised by the defendant. Because of the new issues raised, both parties agreed that the third party, Harmony Homes, though they weren't really a part of the proceedings, they agreed that they should provide the stamped and recorded conveyance dated the 8th of January 2002 between Anthony Munnings and Harmony Homes Limited to decipher whether the properties sold to Quality Business Center in 2007 were in fact the same properties sold to Harmony Homes in 2002. Quality alleged that Mr. Munnings fraudulently claimed to be the sole legal and beneficial owner of the lots and that the said lots were for sale. They further alleged that between March and May of 2007, Mr. Munnings met with Mr. Andrew Wilson, of whom was Quality's director, and he was persuaded into purchasing the lots in reliance of the claim of the defendant. Both the plaintiff and defendant share the same lawyer in this transaction. Under this sale, 3 conveyances were executed with a total of consideration of $260,000. It was then discovered sometime in December of 2011 when Quality had attempted to sell a couple of the lots that the defendant had in fact sold a tract of land which was inclusive of the lots that were sold to them. Due to the defendant's fraudulent claim, the plaintiff lost a total of over $287,600, which includes $260,000 for the purchase price of the lots, $17,600 for stamp duty on the lots, and over $10,000 for legal fees and expenses. Because Mr. Munnings had admitted to selling the plaintiff's 6 lots in the amount of $80,000 instead of 9, the plaintiff was successful in its application for judgment on admission, in which it received the $80,000. In the amended statement of claim, Quality now wanted to claim, as stated earlier, for outstanding loss, damages, and the remainder of lots sold in the amount of $207,600. He further denied that he had sold the same lots to both parties and that the January 2002 conveyance provided by Quality was not an original conveyance. In the amended submissions provided by Mr. Munnings, he raised new issues that were not pleaded initially. His issues were: the signature on the 2002 conveyance was not his. 2, even if it was his signature, the conveyances, including the January 2002 conveyance, were not valid and could not pass the fee simple estate to Harmony Homes because the legal title in the said properties were not yet vested to him. The legal title was passed to him in 2004. And 3, he did, however, recall selling a tract of land comprising of 6.02 acres to Harmony Homes for $100,000 in 2002. On March 12th and March 26, 2018, the trial continued. As ordered by the court, Mr. Keith Bell, the counsel for Harmony Homes, provided the original January 2002 conveyance and had asked the court to declare or confirm that they were the owners of the lots. After reviewing the evidence or the conveyances provided, the court decided that the plaintiff was entitled to damages and interest as a result of the defendant's fraudulent misrepresentation. Also, the declaration was granted to Harmony Homes as they were in fact the owners of the lots in January 2002 conveyance. Although the defendant had not been in the position to convey the lots in 2002, he had created a valid conveyance by estoppel, and when he afterwards obtained the legal title by way of 2004 deed of assent, the estoppel was fed and Harmony Homes thereby became entitled to the full enjoyment of the tracts of land. And a reference is made to a previous case, Noel versus Bewley and the Bridgewater settlement, which were sound authorities for the principle that if a person conveys a defective title and he afterwards acquires a good title, the court will make the good title available to make the conveyance effective. The court made its decision on the basis of the following. The plaintiff never received good and marketable title in fee simple in possession of the lots given that the form part of the valid January 2002 conveyance to Harmony Homes. Based on the 3 conveyances provided, they were executed by the plaintiff and defendant. The first conveyance covered lots 106 to 112. The second covered lot 90, and the third covered lot 92. The plaintiff produced credible evidence to support the claim of the fraudulent misrepresentation, as the 2002 conveyance to Harmony Homes covered a large tract of land inclusive of these properties. Although initially this conveyance was not valid in 2002, it became valid in 2004 when he obtained the legal title by way of a 2004 deed of assent. Harmony Homes filed a summons to declare rightful ownership of the said properties. This was supported by the affidavit of Tavares LaRoda, General Legal Counsel of Sunshine Holdings Limited, and Ms. Shern Henry, a licensed land surveyor. The defendant had claimed initially that it was not his signature on the 2002 conveyance, but it was affirmed that it was his signature by the defendant by Keith Thompson, a judge of the Industrial Tribunal, and Ms. Karen Strawn, who is the corporate secretary at the Sunshine Holdings and its affiliated companies, that they did in fact witness the defendant signing the said document. The defendant also tried many times to delay a final judgment in this action by obfuscating the issues and essentially making meritless and unwarranted applications as the case progressed. The court, in its final ruling, ordered both the plaintiff and Harmony Homes to email their bills of costs to the court and to the defendant no later than 29th of May, 2020, and that they should, and should the cost not be agreed, they were to be brought before the court on Monday, June 8, 2002 at 2:30 p.m. And that's
So in the Tribune, they wrote an article on this case. It says the Supreme Court judge Indira Charles has branded a realtor, quote, a stranger to the truth, end quote, after finding he sold the same land to 2 different buyers, Sir Franklin Wilson and a Bahamian retail entrepreneur. She said in a ruling that Anthony Raymond Munnings appeared to have practiced a web of deceit over many years. After awarding Andrew Wilson, QBC's principal, what's the figure she gave him in damages? Whatever the figure was.
287,600.
Right. She ruled that Mr. Wilson and QBC had been deceived into purchasing 9 Western New Providence lots by the fraudulent misrepresentation of Mr. Munnings, who failed to disclose he had sold the same land 5 years earlier to Sir Franklin's Harmony Homes Company. And when you read the case, it actually tells you what is fraudulent disposition. Remember in this unit 6, and we spoke about the bank and its contractual agreement. We spoke about misrepresentation, which is a false statement of material fact made by a party to a contract or his agent, which induces the other party to enter into a contract. And I told you there are 3 different types of misrepresentation. One was innocent, one is negligent, and the third one was fraudulent misrepresentation. And in this case, they set out the law as to what exactly is fraudulent misrepresentation in paragraph 37. It says that has 4 elements. The representor makes a false representation to the representee. The representor knows that the representation is false, or he is reckless as to whether it is true or false. 3, the representor intends that the representee should act in reliance on it. And 4th, the representee does act in reliance on the representation and as a result suffers a loss. So once a fraudulent misrepresentation is established, the representee may rescind the contract and claim damages. So in this case, you see how he went about making his misrepresentation. So even though Mr. Munnings denied that he had made fraudulent misrepresentation, he instead sought to blame his attorney, Philip Lundy, who he alleged dealt with all the matters relating to the QBC sale. Mr. Lundy also represented both parties in the transaction. Remember last week we had another matter where an attorney represented both parties. Did that go well?
No, and I just
No.
wanted to can't have one attorney representing both sides. Something is bound to go wrong.
Yeah, because you're not gonna see things clearly if you're representing both sides, because all you're gonna do is close the matter.
Yeah.
Shouldn't that be illegal in a way?
Long as you disclose to you disclose that I'm representing both sides and they agree. But don't forget, like in the last case, the court can still fine you. Because you have obligations to your clients.
It just sounds like double dipping to me, like I mean,
Yeah.
which side
Yeah.
you on?
Because it's just like if you're standing before the court and you representing who? The defendant and the accused? I mean, the accused and the person who was harmed? How can you? So you see how Indira Charles with weighed both evidence given, and she said she preferred the testimony of Mr. Wilson. She described it as being candid and straightforward. And it seems as if Mr. Munnings, like he had it plotted. Because Ms. Indira Child's judgment didn't divulge the outcome of any police investigation, but she said under cross-examination, he testified that Mr. Munnings approached him about the deal when in his former downtown Nassau store that was right across the street from Mr. Lundy's office. So these people are professionals, and they plot to see who is vulnerable, and they could get away with making these fraudulent misrepresentation and to sell the same property 2 and 3 times.
Question, was not Mr. Lundy later disbarred?
Was he? I can't
That would
recall.
have been,
I don't know.
that would have been recently.
Oh, recently?
Yeah.
Well, it take a long
Yeah.
time to do that. It's a long process.
Yes.
This is quite a few attorneys going back about 10 or more years, maybe 15 years, who were involved in a lot of the mortgages that were not recorded. They took the monies from the banks, but they never recorded the mortgages. So the bank had no security. So all of them were under investigation and before the disciplinary board. So that's fraudulent misrepresentation. Mr. Anthony Munnings.
So while they are before this disciplinary board or under investigation, they are still allowed to practice.
No,
Okay.
No. No. Mm-mm. Now I give Cleopatra a very interesting one. Cleopatra, you ready to talk about Junkanoo Estate?
Okay, I didn't hear that earlier, but yes, hold on 1 minute. Yes, I have it. Okay. Oh my. Okay, so Junkanoo Estate, we're starting the Junkanoo Estate Limited and others versus UBS Bahamas Limited in voluntary liquidation from the Court of Appeal of the Commonwealth of the Bahamas before Lord Mance, Kerr, Sumpton, Reed, and Hughes. The judgment was given on April 17th, heard on February 2017. Okay, Lord Sumpton saying this is an application for special leave to appeal to the Judicial Committee. Unusually, the application was listed for an oral hearing and a formal judgment is being given in the open court. This arises out of procedural difficulties which have arisen in an ongoing action and for a reason which will become clear. It is important that the basis of the board's decision be understood by both parties and the courts who may have to deal. The application arises out of a mortgagee's action for possession of a residential property at Lyford Key at the Western District of New Providence. The mortgage was granted by Junkanoo to secure its indebtedness under an agreement with UBS Bahamas Limited contained in the commitment letter, August 2011. The second and third defendants, Mr. and Mrs. Starostinko, controlled Junkanoo and guaranteed Junkanoo's indebtedness. They also occupied the property together with their family. Under the commitment letter, UBS provided a credit facility of 1.4 million to the company on terms that at least half of this facility would be available for investment in securities through trading facilities to be made available by UBS. On February 2014, UBS declared the loan in default and demanded repayment of the whole outstanding balance. They alleged defaults were the failure of Junkanoo to maintain the minimum sum under management or to pay periodical interest as accrued. On March 2014, UBS declared its intention to seek orders for the sale and possession or foreclosure on the property. The defendants said that they have a defense alleging the defaults were due to UBS' own breach of their obligations in relation to the management of the invested funds. In particular, failing to provide an electronic trading platform for the investment of the funds under management and failing to carry out certain trades, and a cross claim for damages flowing from the same breaches. As a result of the procedural mishaps, they have never been examined by the courts. And the action was begun in the Supreme Court on October 2014, and a month later, on November, UBS applied for summary judgment. The application came before Evans J. on March 2015. And in the transcript of the hearing, it was put before the board that no real attempt was made to present the defendant's case at this hearing. Counsel for the defendants had by mistake put the hearing into his diary for March, as a result of which Mr. and Mrs. Tarastenko were not present and counsel was not properly prepared. Okay. Okay, so when they had actually went to court, because their counsel wasn't properly prepared, they had to go back. Oh,
They went back and forth for many years.
right.
When did it
Um,
start again? Remind the class when it started. When did they start this court matter?
It's
When was the first time they fought?
hold on 1 second. That would have been 2014, 2011. They started a commitment with UBS in August 2011. And in 2014, UBS
UBS.
declared the loan in default. So it
And
wasn't soon after.
mm-hmm.
But their point of contention was really that UBS had not fulfilled their part of the deal with the investment portfolio part of it. And I'm seeing here that the summary, hold on. Okay, the Court of Appeal, that's on section 5. They were just dealing with Court of Appeal rules.
Mm-hmm. Don't worry about the rules. Go now
Okay.
to section 9. It says the contract of the parties. The relationship between the parties arises from a contract entered into by the appellants with the respondent, a mortgage entered into as a guarantee for the loan by the appellants with the respondent. The liability of the appellants was joint and several. So now they say, let's look at the mortgage itself. So go ahead, start from paragraph 11. It speaks to the law.
Okay. I mean, however, it appears to the board to be right to draw attention to the limited basis on which those decisions were made.
No, paragraph 11. Paragraph 11 says the law. In the English Court of Appeal case of National Westminster Bank PLC versus Skelton.
So are we going to in the Court of Appeal, then the one at the back? No. Yeah.
No, the same one on page 7. Read the Court of Appeal, matter number 24 of 2018.
Hold on.
They went back and forth to the Court of Appeal on different matters, not the substantive
Right.
matter. So
Okay,
read the
so
right on paragraph 11.
you mean the law? The English
Yeah.
Court of Appeal, case of
Yeah.
National Westminster Bank,
Mm-hmm.
versus Skelton. In a situation similar to the appellant's rules, the head note read, by a legal mortgage dated October 85, the defendant mortgages charged their home as security to bank in respect of all present, future, actual, and/or contingent liabilities owed by a company to the bank. Clause 11 of the mortgage agreement provided that the defendants were deemed to stand charged with the liabilities secured, as if they were primarily due from the mortgagor. In February 88, the bank issued proceedings seeking possession of the mortgage property, and the defendants filed a defense and counterclaim alleging inter alia that the company was entitled to recover unliquidated damages against the bank for an alleged breach of duty, and that since the sum claimed would exceed the amount of the arrears, that claim could be set off against the sums owing by the company to the bank, thus extinguishing the company's debt and discharging the mortgage over the defendant's home. The bank applied to strike out the defense on the ground that it disclosed no reasonable defense to the bank's claim against the defendants to to possession of the property, and the judge struck out the defense and ordered the defendants to deliver immediate possession of the property. The defendants appealed, contending that the principle that a legal mortgagee's right to possession of the mortgage property could not be defeated by a cross-claim on the part of the mortgager was not applicable, where the cross-claim would give the mortgager rights by way of an equitable set-off, or where a mortgage was merely by way of guarantee intended to afford security for the debts of a third party.
Okay, so stop right there. Explain to the class what exactly were the Starostenkos claiming.
Okay, they were saying that they entered into a mortgage with the bank, but they had the bank had other obligations to them with the investment portfolio part of that agreement that was not met by the bank. So therefore they wanted what they owed the bank and what the bank they should have gained from the bank through the investment portfolio for it to be just a washout.
Right.
Which couldn't
So they
happen.
they did a cross claim between the two.
Right.
That's what they were doing, a cross claim. And so you see where they're presenting a case that is very similar to what they're presenting.
Right.
Okay,
But that case was struck out,
all right.
and those persons still had to give vacant possession to the bank. So
Mhm.
in essence, this is what will happen to them.
Keep going. You know, I know it's kind
Okay.
of not that long. Just the relevant ones.
Okay.
Cleopatra, are you reading from, please? Because y'all lost me.
You lost. We're reading the Court of Appeal case, number 24 of 2018, Junkanoo Estates, and Yuri and Irina.
Oh, no, the second one.
Okay,
Yes.
that's on page 7, 8.
Okay, thanks.
Okay, 12. At page 248 of the judgment, Slade LJ said, in these circumstances, I will assume in favor of the defendants without, of course, deciding the point that if the case were allowed to proceed to trial, well, they would or might be able to establish that at all material times the company was entitled to a claim for unliquidated damages by way of set off against the bank in an amount which equaled or exceeded the debts said by the bank to be secured by clause 1 of the mortgage. And even on those assumptions, they think neither paragraph 7 to 12, nor indeed any other paragraphs of the defendant's pleading afford any ground in law by way of defense to the bank's claim to immediate possession of the property. Okay, now, you want me to finish that sentence? I mean, the paragraph?
No. Go on, because they gave quite a few case law.
Okay, so the general rule established by long-standing authority is that except in so far as his rights are limited by contract or statute, a mortgagee by way of legal charge is entitled to seek possession of the mortgage property at any time after the mortgage is executed. So
Which paragraph you just read that from?
that was 12.
Okay, so
And,
go to 16.
16. Okay.
Mhm.
16 is saying during the course of his discussion, Slade LJ made reference to what Buckley LJ said in
Mhm.
Western Bank Limited. A legal mortgagee's right to possession is a common law right, which is an incident of his estate in the land. It should not, in my opinion, be lightly treated as abrogated or restricted. And Mercury and Wade's a law of real property under the rubric to take possession indicates that a mortgagee may go into possession as soon as the mortgage is made, even if the mortgager is not guilty of any default.
And
Okay,
then Kalina Imperial Insurance, paragraphs 32 to 35, what it says.
subject to the caveat that the mortgagee's right to possession is also subject to statute, I would agree with the opinion expressed by Harmon J. as representing the law with respect to the right of mortgagee to possession. And the reason he has that right is that on execution of the mortgage, which is achieved by conveyance of the legal estate, he becomes the owner of the legal in estate in the property, which vests in him on execution. So accordingly, as an incident of that legal title, he is entitled to possession. Okay, and they cited another case here, Ashley Guarantee PLC. There's an action for possession inter alia. The defendant sought to deny the plaintiff's right to possession on the grounds that there was cross claims that exceeded the amount which the plaintiff contended was outstanding on the mortgage. And the court held that a mortgagee's right to possession could not be defeated in these circumstances because the mortgagee had, as an incident of his estate in the land, a right to possession of the mortgage property, and cross claims could not be unilaterally appropriated in discharge of the mortgage debt. So
And then Jen Patsy again in Citibank versus Major, where he stated what? The position at law is that
where under a legal mortgage, being an installment mortgage, the whole money becomes payable by reason of the default of the mortgagor, and the legal mortgagee is entitled to possession of the mortgage property. The court has no jurisdiction to refuse to make an order, but this does not exclude a power to direct an adjournment for a short time to enable the mortgagor to pay off the mortgage in full or otherwise satisfy the mortgagee if there's a reasonable prospect of the mortgagor being able to do so. So that means they have to give them a chance to try to pay it.
right. And then he goes in paragraph 19, citing the case of American British Canadian Motors versus Imperial Life. Decision of
Down at the bottom, Gonzalez Zabola. The Chief Justice was faced with a challenge by 3 litigants who sought to avoid paying exorbitant interest due to their default in the payments of their mortgage. At paragraph 6, he said, would that be, okay, the case of McLeod versus Jones was cited as venerable authority for the ordinary rule that the court will not grant an how do you pronounce that? Interlocutory injunction to restrain the exercise of a mortgagee's power of sale, except on the terms of the mortgagor paying into court the sum of money sworn by the mortgagee to be due for principal, interest, and costs. So that's giving them a chance to catch up and bring it in order. In that case, were emphatic that was the practice of the court. The mortgagor must bring into court the money demanded of him and sworn to be due from him under the mortgage before he may qualify for the relief of a court of equity. And I agree with the submission of counsel for the defendant that to allow any other course would create havoc in the marketplace. A mortgagor fought with the mortgagee's funds who seeks to avoid the mortgage instrument when the power of sale it confers is sought to be exercised, has no right to come empty-handed to court to restrain the mortgagee. Had the rule been otherwise, it requires but little imagination to foresee how a succession of defaulting mortgages temporizing with technical objections could employ the injunction to constipate the cash flow in the mortgagee's business and frustrate its normal course with all the serious implications that entails.
So what was concluded?
Okay,
Paragraph 26.
the conclusion, I am satisfied that whatever relief the appellants seek must be found elsewhere than from the respondent. In the premises, I would answer the question posed in the affirmative, but with a caveat. The caveat is that the applicant will have to demonstrate a strong balance of probability case that the court should interfere. Nevertheless, my positive findings is of no avail to the appellants, as there has been no basis shown for this court to interfere with this decision made by Evans James. Ultimately, the appellant's claim against the respondent sounds in damages, and their counterclaim against the respondent remains in the court below awaiting determination. Should the appellants prevail on their claim, damages will be assessed based on such provable losses as they are able to show. For myself, I would dismiss this appeal with costs to the respondent, such costs to be assessed if not otherwise agreed.
Okay, so again, when did this matter start?
This matter started.
You said commitment was done
From
in
2000,
2011?
from 2011. No, the mortgage was started 2011. This started 2014. And this,
2004.
mhm.
So
And then
it-
this is now, what, March of 2020? Before this
Yes.
was really completed?
So in the blog, the star, what is the name again? The Staronstenko. They-
Stenko, yes, ma'am.
Yeah,
Mhm.
they said on 27th of February 2018, the execution, they got a writ of possession, took place in the form of an illegal distress. This is their words, where illegality occurred for the bailiff with forcible entry, and where the police powers of entry and seizures were used unfairly, irresponsibly, so without respect for them, and 5 minors being actually physically expelled by force from the premises with unlawful discrimination, harassment, and victimization, and in the violation of human rights of children under United Nations Convention on the Rights of the Child, including physical and oral assaults against one of them who is a minor, and key principles of the Human Rights Conventions, the right to privacy and respect for personal property. This is what they wrote.
Yes, but then the property really belongs to UBS.
Mhm. So they said, they wrote here that they, along with their children, were forced out of their dwelling home of 10 years under an order to pick only things for one night, and a promise on the part of UBS to be able to come back the next day and collect necessities for living and studies of children. So the
They didn't
execution,
even have to do that.
no, so the execution amounted to, in law, to a wrongful and unlawful eviction by trespassers, actuated by malice and orchestrated by UBS and its agents in a conspiracy. So the police force of the Bahamas have so far ignored a report regarding acts of violence against children committed by bailiff and locksmith during the course of the eviction, filed by Mrs. Starrens, whatever their name is, Star, and did not answer to the letter which they wrote to the Commissioner of Police. The UBS and his attorney acted maliciously. So after the eviction, they applied in writing to and sought by phone calls from the Court of Appeal for an urgent hearing of their substantial appeal and or reconsideration of the refusal to hear their applications, including an application against the order of Honorable Sir Michael Barnett. But the court remained silent. So they went internationally and they actually badmouthed the Bahamas on this whole matter.
Yeah, but they were at fault.
Yeah, because they tried to do a cross claim. They're trying to say, you see, they got this mortgage and then they sign an investment agreement, investment portfolio to do a trading. And so their whole premise was that they will trade on the platform And then the money they make from the platform, then they will pay their mortgage.
For everything to have been straightforward and above board, if they were doing that, they should have done that platform with another institution. That's the only way that could have worked.
Yeah, but again, how are you going to do that cross claim? Even if you did that with another institution, you think a bank would actually give you a mortgage with the premise that payment will come from the chance that you may win? That's a chance, you know.
Right, yes, it is. Yeah, because.
Which bank is willing to take that risk? The payments won't be
any.
consistent.
Right, this payment, I mean, when you grant a mortgage, normally it's based on actual income, not, I guess, something that would be proposed or future income. You don't know
Exactly.
if that's, you don't know if that's going to be actually coming in monthly or how that's going to be received.
Mhm.
Yeah,
And their argument from the very beginning was that they would not have gotten the mortgage if they knew that UBS would not have been able to make the money to pay the mortgage.
But they knew they didn't have a platform as yet.
Yeah, but of
Yeah.
course, when you read the blogs and read in between, people will do anything for a free house.
And did you notice that one of the attorneys appearing for them was Philip Lundy?
No, as you say that, no. As you say that.
Yes. On
Ah,
front.
yeah. I remember seeing Mario DeSille, but I never saw that little Lundy and stuck on the side there. Okay. Bright eye. No, I didn't notice he was there. But yes, that's Mr. Lundy again. Very active. You know, this matter went all the way to the Privy Council and came back down to the Court of Appeal. They were fighting all that time to stay in this house for free. Believe it or not.
But like the court said, they had to come to court with money in hand to pay whatever arrears. Then you have a fighting chance, but you come empty-handed to court.
Exactly. And then you go internationally and begin to bad mouth the judicial system. But I mean, any lawyer who would have taken this case should have sat down and say, like we just said, and like the case has said, you come with money in hand. You sign a mortgage.
It's expected that you pay.
And it's like, right, you sign an agreement that you will pay monthly. That was not contingent on whether or not whether or not the trading platform was up and running, and two, whether you make any money on the trading platform. No, it's not possible. But they lived in that house for 10 years for free.
Yeah,
Without
because of that case.
Yes. They dragged that through the court for 10 years for free. It's really amazing what people will do. I think, Janique, you have Roll Family.
yes, I do. Go ahead, start.
Yeah, go ahead. You learning plenty tonight, eh?
Sure, it's a whole lot. Okay. This is Roll Family and Company Limited, the appellant versus Roll, the respondent. And this went up to the Court of Appeal. Before I get started.
No, Privy Council.
That's Privy?
Mm-hmm.
Court of Appeal of the Commonwealth of Bahamas from. Okay, now so that answered my question then. I was asking about the board because it kept referring to the board. So the board is the
Privy Council, yes.
Okay. This matter was on this dispute was over 2 plots of land in Bimini.
May 24, 2006, Emmanuel Rule conveyed 3 plots of land to his daughter as a gift. Then, a few months later, he conveyed the same plots to it's a Rule Family and Co. Limited, but it was his son was the principal, and he sold it, more or less sold it to him for $100 each. Section 10 of the Registration Act states that whichever conveyance is recorded first, they have priority to ownership. And
Go ahead.
and Paul, the Ruleville family, the company, they recorded their conveyance on May 22nd, 2007, and the sister did recorded her conveyance July of the same year. Okay, the issue with Paul's conveyance was the lawyer was instructed, because it was a company, the lawyer was instructed to have a grantee as a part of the incorporation of the company, and the formalities were not completed, and the company did not come to an existence until September 2006, which was after the father would have given him the company, conveyed the company to the son, or the plots to the company. Although the conveyance were executed, the grantee didn't exist. So the grantee in existence in whose favor the deed could be delivered, there wasn't any in existence at the time. The general rule of the company law is that no company can adopt or ratify a transaction purporting to be made on its behalf before it is incorporated. So the case of Native Land and Colonization Company versus Pauline Colliery and Development Syndicate Limited was used in this regard. And in ordinary course, the result would be that the conveyance in the company's favor was void, mainly because of there not being a guarantee. The incorporation wasn't finalized. The Rule family was seeking to avoid this issue by submitting the conveyance. So it used 2 aspects. It submitted the conveyance of the 8th of September, which was delivered in escrow, conditional on the incorporation of the company and taking effect as valid grants when the condition was satisfied. The company, or the second one was the company relied on Section 22 of the Companies Act, which validates pre-incorporated companies on certain conditions. So they were trying to use these 2 or use them as part of their defense or their support why they have proper ownership to the land. Both points had some checkered procedural history. So the company relied exclusively on the second point in regards to the act when it went before the trial judge, who rejected that submission or that stance. So it went to the Court of Appeal, and they leaned more on the first issue, which the court also dismissed because it lacked substance to some degree. So at the court, they lost their case also at the Court of Appeal. So in going to the definition of the escrow, which they were trying to use, is that an escrow is a deed delivered on the basis that it is not to become the deed of the party making it until some condition is satisfied. In this case, the condition was the existence of a grantee. So everything was in place, but the condition, they were waiting on the grantee. The Court of Appeal declined to treat the transaction as a valid escrow on the ground that upon the satisfaction of the condition, the grant was deemed to relate to the date of delivery. The company did not exist at the date of delivery and there was no grantee. So that was the call of Court of Appeal stance. The main objection to the supposed escrow is namely that the deed cannot validly be delivered in escrow on a condition to that coming into existence. This is because although delivery of a deed in escrow suspends the effect of the deed as a grant until satisfaction of the condition, it creates legally binding obligations from the moment of delivery. The maker of the escrow cannot, for example, recall it before the condition is satisfied or dispose of it, of an interest in the land consistently with it. So they're saying that there is some binding related to an escrow. And the case of Windsor Refrigerator Company Limited versus Branch Nominees Limited states that if at any time the delivery of a grantor lacks capacity to assume even a conditional obligation, for example, because he is a minor, there cannot be a valid escrow. And it can make no difference that the acquired capacity by the time that the condition is satisfied. A deed proponently delivered to a non-existent party could never be more than a statement. So this is more or less, they're saying this is just more or less a statement of intention, recallable at will, and could not therefore be said to have been delivered. This makes it unnecessary to consider whether there is sufficient reason to suppose that Emmanuel Rule intended to deliver the deed in escrow, or whether in the absence of any pleaded case to that effect. This point should not be even entertained. Now, the Companies Act, which the family was trying to use at one point, I think that was at the appeals court. So the Privy Council was actually reviewing the different stance they took on the decisions based on that. So what they were trying to say, part of the Companies Act states that a person who enters into a written contract in the name or on behalf of a company before it is incorporated is personally bound by the contract and is entitled to the benefits of the contract. Another one part of the Companies Act is within a reasonable time for the company, after the company is incorporated, it may by any action or conduct signify its intention to be bound thereby, adopt a written contract entered into in its name or on its behalf before it was incorporated. It also states that the company is bound by the contract and is entitled to the benefits thereof, as if the company had been in existence at the date of the contract and being a party to it. So these are some of the parts of the act that they were trying to use. And the effect of these provisions is that an instrument which purports to be an agreement but is void because there is no counterparty in existence is nonetheless deemed to be an agreement for the purpose of binding. The person who purported to make it on behalf of the company and the company itself, if it adopts the transaction in accordance with the subsection, is in place of that person. So the board stated that the Rule family, yes, they entered into the contract. So part of the board's part of their discussion or their right, what they just, I don't know what the right word is, but part of what the board stated was, yes, the Rule family entered into a contract. And the fact that money was transferred over, it is, in the board's opinion, the transaction effected by the deed was a bilateral transaction involving mutual obligation. In other words, the board stated that it was a contract, so the board agreed that there was a contract. The board also stated that in the present case, the payment of stamp duty and the lodging of the conveyance at the registry in the company's name unequivocally signified its assent to be bound by the deed. So there was a deed, there was an agreement, and the company intended to be bound by it. A part of what was also discussed was a part of the agreement a part of having the conveyance recorded, the finalizing a transaction should have been in reasonable time. The issue that the Roll family had, them recording the document was not in a, no, the question was, what is a reasonable time? So stating a reasonable time, there was no specific days, months, or years placed on it. So the question was that, was the recording of the document, I think it was a few years later, I'm not sure, a year or more later, was that reasonable to say they have claim to the property? And the board accepts that there's room for argument about how long was reasonably required, but it considers that the 8.5 months that had elapsed between the execution of the conveyance and the stamping and the lodging of the deed for registration was well beyond a limit of reasonableness. The full trial judge dismissed the action on that ground. The board considers that he was entitled to do so, so the board agreed with the judge in dismissing because it was not considered in their eyes reasonable time. So this left it open as to the unresolved question, who does have title? If the Roll company, the Roll family company limited didn't have title, who would have title? This leaves unresolved, the unresolved question, who does have title? It was not necessarily the sister, because it is arguable that since the transaction is void at common law and the company cannot claim title, so because the sister took just as long as the brother. So the act, the legal owner is the son, Paul, by virtue of section 22. Another possibility is that the sister might derive rights from the fact that the failure of the company's claim leaves her as the only claimant on whose behalf any conveyance has been lodged registration with the registrar of records. So the sister is more or less saying, she didn't say it, more or less that she had her documents recorded properly to some degree versus the company and Paul. So she could be looked at as a possible owner or the correct owner. The only question under this head, which the board thinks is right to address, arises out of submission made on behalf of the company to the effect that if Paul Roll has the legal title to the 2 plots by virtue of section 22, he would hold it in trust for the company. So they said Paul Roll was the proper owner because he acted on behalf of the company and so forth, and versus the company owned it, then he would have to hold it in trust for the company because he was working for them more or less at the primary owner, working for them to some degree. The scheme makes the company's interest in the transaction dependent on the adoption of the transaction within a reasonable time. So the board still went back to the issue of what is reasonable time. Equity cannot intervene to create a trust inconsistent with the statutory principle. So reasonable time was an issue, the main issue. So it was decided by the board that accordingly, the board will humbly advise Her Majesty that this appeal must be dismissed, subject to any written submission which may be addressed to the board within 14 days. The company must pay Eno Roll's cost of the appeal. So that, from my understanding, their main reason or the final word on why they actually lost the case was they based it on the reasonable time. It was done in reasonable time, so the sister still was left with the property. Am I correct?
Partly, don't forget now. So what he did was he conveyed it to the daughter first and then to the company. But the company was not in existence. And under the Companies Act, when you engage in a contractual agreement on behalf of an entity that is not in existence, one, you do it at your own expense. Or you can do it with the consent of the subscribers to the company, that they will ratify that contract as soon as it is incorporated. Now, what they were saying, the board was saying, is that by the act that they actually did the stamping and the recording, you can say that there was the intent to ratify from the beginning. But of course, when you read the act in its totality, it speaks to reasonableness. So if you're in the process of incorporating a company and you carry out an act before it is incorporated, it is envisioned that as soon as that company is incorporated, you ratify that contract. That's what it means by reasonable time. And they didn't do that. Neither party did it in a reasonable time. And so that left the whole question open as to who actually owns this property. It couldn't be the company because the company was not in existence. So the only person that can actually own this would have to be not the company, but the brother himself. But he was not a party to the action. So that means they have to go back now, and the sister has to now bring an action against the brother.
But didn't it say that the sister, at the end, the company must pay her cost? So that doesn't mean that she owns it. Why is it that she have to take an action against the brother? That doesn't mean she won the case?
No, she didn't.
So who won the case?
Nobody won the case.
Nobody.
So who owns the property?
They have to go back to court. The court now has to both sides now have to bring their evidence as to why they think they own the property.
Okay, is it that the father has deceased?
Let me see.
Because
No, they say he
I'm
did
not
it
hearing
by,
any other mention of the father anymore.
he did a gift.
Okay.
He did a gift.
So in a case like this, if the father is alive, can he come forward and say, instead of going through the court, can he live?
What his intentions?
Right.
Yeah, everything comes to his intention. So he now has to give evidence. He has to file an affidavit as to what was his intention. One, when he gifted it to the daughter, and then two, he turns around and he sells it to his son via a company that is not created. Now, his affidavit may only speak to why he turned around and sold it to his son, whereas he had previously gifted to his daughter. Because that sounds to me like there is some mental issue
Yes, on the part of the father.
on the part of the father.
Right.
And the son didn't want it in his name, so he decided that, guess what? I want the property in the name of a company,
Mhm.
but the company was not yet incorporated. But everything will go back. Remember, in law, everything goes back to intention. What were the intentions of the party when they entered into the contract? And that is what the son is going to have to rely on.
Yeah,
For the-
but it seems
Right.
as though the father's not available anymore.
Well, someone has to come up with what was the intention. So it'll be the daughter's word against the brother. or someone else who can give an affidavit as to why the father did what he did.
But didn't this actually stem from the fact that they were fighting over ownership? So this means that they're going back to square one,
You have to.
same thing? Again?
Yes. Uh-huh. What was the intention? What was the intention of the father when he gifted the property and then he turns around and he sold it? Doesn't that tell you that something is not right?
Yes.
Yes.
Because if he has already gifted it, and then that property was conveyed to the daughter, then did he have a right to sell it?
No.
But it all comes to recording. If she recorded hers first, then she'll be in the clear.
And I guess the father done spend the money, so we ain't giving the son back the money.
Exactly. And then she recorded hers after the son. You see, so she jammed her own self.
Wow.
When she got that gift, she should have recorded it right away. Remember, the law of equity speaks to first in time. And this happened a lot in the past in banks where a person will go to 2 different banks and get a mortgage. It's whichever one is first in time.
Miss Archer,
Mm-hmm.
for our exam, we studying 1 to 4, right? You giving us any tips on the exam?
Tips. Okay, y'all want me to stop now. Let's see.
I just want to
Hold on,
say,
baby.
are we stopping for the night? Because I haven't presented my case, so that's next week, then
If you want to do it tonight, we can.
we need to go over the exam though, and I'm just noting the time.
The exam is multiple choice.
Yes, ma'am. Could you
Then
let
I-
us know what mode of delivery is going to be used? What is the time? Do we know any of that? And it's still Wednesday, right? The 17th, yes.
Say 3 hours. I reminded Mr. Pratt. It's
3?
multiple choice. I may ask him if let me see if he can come on.
What 3 hours is that?
You don't need 3 hours for multiple choice. You probably only need
I
an hour.
know, but I'm trying to figure out that's what, 6 to 9?
I'm gonna ask him right now. See if he comes on. I gave you all some examples of the multiple choice questions last week, and you all were on the ball.
Oh, boy.
Remember?
Yes, ma'am.
These are not hard. You may have to think a little bit, may need more than an hour. Maybe. Okay, listen to this. And I know you can have the answer. I'm waiting for him to come on. On default of a mortgage, the mortgage will bring which remedy first? Action to debt, foreclosure, power of sale, all of the above.
All of the above.
Wrong.
Repeat the question, please.
But she
On
said which one
default
do
of a
first.
mortgage,
So something have to come first.
on default of a mortgage, the mortgage will bring which remedy first?
First, okay. Go on.
Action to debt, foreclosure, power of sale, all of the above.
Action to
sale.
that.
Foreclosure.
Mm-mm.
Power of sale.
Mm-mm.
Foreclosure.
Action to that.
Action to that.
Debt.
That's the demand, eh?
Yes.
Why are you trying to be tricky, Miss Archer?
It's not tricky.
Yeah, Miss Archer, you supposed to say demand letter.
No. No,
Then we would have known for sure.
the
That's what it's
document,
the point.
hold on. The document is called a demand letter,
Uh-huh.
right? But don't forget now, in the law of conveyancing and in mortgages, we're speaking about now remedy, not the name of the document. It's a remedy. And the remedies are action for debt, foreclosure, power of sale. Those are action, appointing a receiver. Those are the remedies that are available, not the name of the document. So stop panicking. Take your time, read it, and pick the best answer.
You said it's 50 questions.
Yes, ma'am.
Ms. Archer, how's the exam going to be administered, please?
That's what I'm trying to get Mr. Pratt on now, so he can come on.
Oh, okay.
I'm trying to get him to come on to see, because it's multiple choice. He should know how he does it. So while I wait on him to answer. So next week we have Dora, may I had you down for 2 because you missed one.
Oh,
Or one. No, just one. You have the Maycox to do, right?
That was the maker?
Don't you have BOB and the Maycox?
Yes, from the last one, eh?
Yes. So you'll do that one next week.
Okay.
And then Demetria, you had Scotia and Cube.
Yes, ma'am.
All right. And so Wish Name told me I had not assigned one to her. Thompson. So Thompson, I'm gonna send you a case. How's that?
Thank you.
Okay, I'll send you your case. And then if I have any more, I will assign, but no, I don't think no. That's it. Next week, we're gonna look at the documents. I'm sure most of you are familiar with the document examination, the document. So we're just gonna look at the clauses. Yeah. We're gonna look at the clauses, and then when we look at Scotiabank and Cube, it actually goes through the mortgage from the commitment letter to signing the mortgage, and then the breach of contract. Okay, so let me see if I can find Mr. Pratt, see what he's doing. I forget you all up to study.
We have to study the Homeowners Protection Act for this,
No,
okay, Grace.
that'll be in the final exam.
Okay.
Boy, Demetria, thank God you asked that question, because I was going to
No,
study.
don't forget. That's why I only did it from 1 to 4.
All right, so,
Did 5 and 6 and 7 and all of that. Then you would have the Homeowners Protection Act. So I left that because we have a lot of case study on it. I think it'll be easier to do it in a scenario, rather than have you trying to memorize that for multiple choice.
Ms. Archie's one sound like you working with us, but I can say that after I don't see the test.
Oh, Lord. Of course, I'm working with you. These are not hard. These are not hard. You just have to don't jump for the first answer. Just go through it and see what's the best answer. I'm trying to get him to come on.
Ms. Archer, I guess if you could just tell us whether it's online and we don't have to actually go in to do it, will help.
That's what I'm trying to figure out now, if it's online.
Oh,
You want me to just let him send something?
Say again?
You want me to let him just send an email?
Yeah, you can do that. That's fine. I mean, for me, I don't know about everybody else.
Yeah,
Yeah,
because
if you've
I'll
got
have to
it,
hang up
you
in
can
order
say
for
what
him to
time it
call him.
was.
That's fine.
Okay, all right. So we'll end now and let me call him and I'll tell him send you a note.
Thank
Okay.
you.
Yeah,
All right.
and I'll tell him you prefer it online. Hopefully you'll have it where he could just set it and you could do it.
Okay.
Okay, all right.
All right, good night.
Good night.
So good luck.
Good night.
Thank you.
Night.
Good night, good night, good night.
Bye.
Good night.
Good night.